She is the commissioner of the EEOC, the Equal Employment Opportunity Commission, charged with ensuring that private corporations and, for that matter, governmental enterprises don't conduct and contribute their business while implementing discrimination. It is Andrea Lucas, and she joins us now here on The Will Cain Show. Andrea, thanks so much for jumping on and helping us understand the lay of the land, not just the law, but what's happening right now in American hiring practices. And I would love to start with this. I know you can't address specific companies that are involved in litigation or in cases, but I don't think I have to, or you don't have to in your answer, address perhaps certain corporations because it's so widespread what's happening right now when it comes to hiring. And I think I'll start with Amazon, and we can put it up on the screen. I want you to take a look at something Amazon has on their hiring practices. And they put specific quotas, Andrea. They say the minimum aspirational goal for casting across speaking roles are 30% white men, 30% white women, and non-binary people. I guess that's in the same quota group. 20% men from underrepresented races and ethnicities, 20% women and non-binary people from underrepresented races and ethnicities. It goes on. You can see other quotas underneath, 10% for people who are lesbian, gay, bisexual, transgender. As I mentioned, Andrea, this is from Amazon's internal documents. There are many corporations doing this right now openly. Is this legal considering the Civil Rights Act?
Well, thanks so much for having me. And like you said, while I can't speak to any specific company, part of my practice is to review the landscape of what major corporations, what the widespread practices are when it comes to hiring, as well as promotion, training, a whole host of employment-related actions, all of which are covered by Title VII. So that's a key thing to start with. It's not just hiring, firing, compensation. It's also access to a host of benefits and even access to interviewing. And I can say, as a broad matter, it has become extremely widespread across much of the Fortune 100, maybe the Fortune 500 even. It's primarily large to mid-sized companies doing this. Very routine to have hiring goals. And whether or not they're legal does vary. If they're quota, they're absolutely illegal. And then there's a whole host of risks that can come around having a hiring goal depending on how it's structured.
So quite clearly, you're stating quotas are illegal.
Yes. And it shocks me the number of times that I see a diversity activist or a DEI proponent missing that key point of the law. There's no scenario in which you can do a quota. And also, you're not supposed to be doing racial balancing. So that's, if you're just trying to mirror the general public. I see that frequently for many companies. They set these goals, and the goals are wildly unrealistic. They're based on nothing other than looking at the general American population. That's also going to be a red flag because if you have a really unrealistic goal that you're hitting, let's just be real, right? How do people respond to hitting an unrealistic goal, especially when you put financial pressure? They're going to often take the easy route, and that route is unfortunately race or sex discrimination. You're recklessly forcing your managers into making illegal decisions if you're setting a goal that they could never meet but for discrimination. And then you're tying their compensation, their viability at the company, right, a host of incentives to make sure that they hit those unrealistic goals.
So that leads to the obvious next question. Then why are they doing this? Or rather, why are they getting away with it, and why are they so proudly violating Title VII? I think I'm correct here, and I want to read from the pertinent part of the 1964 Civil Rights Act, Andrea. And it is Title VII of the 1964 Civil Rights Act, and it's from my understanding what we're talking about is Section 2000. And it reads as follows: it shall be unlawful for employment practice for an employer to, one, fail to refuse to hire any individual or otherwise discriminate against that individual with respect to his compensation terms, conditions, because of that individual's race, color, religion, or national origin. It goes on to say, number 2, that it's illegal to limit, segregate, or classify employees or applicants according to an individual's race, color, religion, sex, or national origin. Is that the operative part we're discussing here of Title VII?
Yeah, those are the 2 key provisions. I'll also note that there's a separate provision that covers training programs. And that's another big blind spot for a lot of companies. They get focused in on thinking this really only relates to hiring, firing, compensation. And they forget that if you're providing internal training, Title VII has a standalone provision that says that you cannot discriminate in admission to training, including on-the-job training. So we see a lot of programs like leadership development programs, internships, things that people are thinking are something other than those big tangible material decisions, but they have real implications for employees' prospects at a company.
Okay, so that, as I mentioned, leads to the question of how are they getting away with it? You were on Fox and Friends Weekend with me this past Saturday, and we talked about that, and you brought up why this hasn't become an enforceable mechanism, Title VII of the 1964 Civil Rights Act. Here's what you said on Fox and Friends Weekend.
A lot of it's a matter of incentives. If people aren't suing about it or filing a complaint or speaking up, it's difficult to change things.
So what you're telling me is you have no plaintiffs, you have no one making complaints, you have no one lodging violations of all these corporate policies that on their face proudly are talking about using race as a practice in hiring.
Well, I do think in the last 6 to 12 months, we've seen a significant increase in people being willing to speak up about these practices, file EEOC charges, proceed to litigation. And we are starting to see across the legal landscape many different challenges on this front. So some of it is a matter of things working through the administrative process and through the court system. But historically, yes, I think there was certainly a period of time in which people just were not making their way through the process. So in order to go to federal court on a violation of Title VII, you first have to file an EEOC charge. If you don't do that, you can't proceed to federal court. So first you'll go through the administrative process, and then you'll go to federal court.
So to be clear, Andrea, this needs to be brought by a complainant. So in other words, Elon Musk just tweeted out, and I know you can't speak directly to Disney, but he just tweeted out some of Disney's hiring practices, which reveals very similar to Amazon, quotas on what. And by the way, Andrea, I don't think this gives them an escape valve, but what I think doesn't matter. It matters what you think. To say these are aspirational goals, that seems to be their perceived escape hatch. But in order, say, for Disney, who says their aspirational goals is to fit these racial quotas, but also various identity-based quotas, the EEOC can't itself bring a complaint. It requires somebody within that corporation to complain about these discriminatory practices?
Not quite. So the primary basis for doing it is, yes, you've got to be an employee or a former employee or an applicant. So if you interviewed and you didn't get an interview, you also have the ability to bring a complaint. That's the primary way to deal with it. The other option is you could have a third party file a charge. So that's a situation where you have some sort of nonprofit or legal organization that will represent employees. They can remain anonymous in that matter. So that's a third party EEOC charge. And then the third vehicle is a commissioner can bring her own commissioner's charge if she sees discrimination. But the primary basis is having a plaintiff bring it.
I'm curious there, since the commissioner can bring her own charge if she sees it. Are these types of quotas that we're seeing from various corporations not on their face violations of the Civil Rights Act that you could bring, according to what you just told us, you could bring an EEOC violation?
Well, I can't talk about any specific, specific company about what I would conclude it was or was not a violation. But yes, I do have the power to bring a commissioner's charge. They have to remain confidential, so I can't confirm or deny whether or not I've brought anything to that front. We do publicly report the number of commissioner's charges across the board that commissioners bring, but all charges are subject to confidentiality.
How often do you publicly report the number of commissioners' charges of EEOC violations? Is that quarterly? Is that annually?
On an annual basis, we report how many commissioners' charges are brought, and we also report the number of charges that we're receiving on a host of things. So we have a whole stats on race discrimination. You can look at that. We also have other things on our website that'll talk about some notable race discrimination cases. And I think, one other reason that I don't think we sometimes get people filing lawsuits or pushing back on policies is there's just widespread perception that the race discrimination laws and civil rights laws only protect certain groups. But the civil rights laws are colorblind. They apply to everyone of every race, color, national origin, and creed. They're not only available for racial minorities, they're available to everyone, whether they're under or overrepresented. All of these terms, it's not restricted. So you do have some people thinking, oh, these civil rights laws aren't for me. That's not what discrimination is. Discrimination is taking action based on race or sex. It doesn't matter if you're white or black, Asian, Hispanic, in which direction it's going. If you're acting in whole or part based on race, you're violating the law. So I think a lot of people have sort of counted themselves out from pursuing claims.
Just a few more questions here with you. But that being said, you still say you've seen an uptick in the number of claims over the past, I believe you said earlier in our conversation, 6 to 12 months of complaints of violations of the EEOC. I don't have your reporting in front of me. Does that bear out in your reporting whether or not they're commissioner violations or complainant violations? Does the reporting reveal that those numbers have gone up over the last couple of years?
It's too soon to see. We haven't reported out our fiscal year 2023 data on that, so I can't disclose that yet. But the other thing is there's more than one vehicle to sue about these things. Some and many plaintiffs are pursuing Section 1981, which is another civil rights law. That law relates to contracting, but employment decisions often fall under that. So there are a number of plaintiffs that are going straight to federal court under that vehicle, and we don't track that data. But I'm watching that constantly as a legal observer of these types of claims.
All right, last topic. We talked about direct quotas. We talked about some of these hiring practices that companies seem to be proud of. But then there's another approach, and that seems to be the approach of Dallas Mavericks president of basketball operations, former owner Mark Cuban, who you had an exchange with on X. Cuban seems to be thinking he can use race as a tipping factor. In a statement that you ended up responding to, he said, "I only ever hired the person that will put the business in the best position to succeed. And yes, race and gender can be part of that equation. I view diversity as a competitive advantage." To that, you responded to him, "Unfortunately, you're dead wrong on the black letter law of Title VII. As a general rule, race and sex can't even be a, quote, motivating factor, nor a plus factor, tiebreaker, or tipping point. It's important that employers understand the ground rules here." So if Mark Cuban were doing what he says he is doing in his companies, what you are saying to him is you are violating the Civil Rights Act.
Any employer, as a general rule, that is admitting that they're using race or sex, even in part, yes, they're admitting that they're violating the law. It's just very basic law. The general rule is you are not allowed to use race or sex or another protected characteristic in whole or part. A lot of people had confusion over this because in the university admissions case, prior to the Supreme Court in June overturning affirmative action in university admissions, you previously could use diversity for school admissions. You could use it as a plus factor. So basically exactly what he's articulating, that used to be the old rule in university admissions, but it was never the rule in employment law. A lot of people just conflated the two. They thought what was okay in the university context was fine in employment law. It never was. It's also not the rule anymore in university admissions. The general rule across the board for civil rights laws is that you are not supposed to be using race or sex as a component of your decision making.
Last question, Andrea, and this is going to require a bit of conjecture on your part, but these companies and these CEOs are open to the point of pride about these discriminatory policies. Is it your estimation that they are ignorant of the law under the Civil Rights Act? Or is it that they do not care what is the law under the Civil Rights Act because they do not fear punishment?
I think probably 50-50. I think there's a portion of people who have a rudimentary understanding of what the laws are, and they've got those common misunderstandings, I think, like Mr. Cuban, that as long as it's just a little bit, right? Just a little bit of race discrimination is okay, right? Or they think that race discrimination only applies if you're discriminating against a racial minority, right? Those are the two misconceptions I think a lot of people have. And then there's a portion of people who probably have heard from their lawyers that what they're doing is illegal, but there's very low practical risk. And so they choose to go forward because they think that pursuing diversity at all costs is a business imperative, and they're not going to get sued about it. That after the last 12 months, I don't think that's a good risk assessment anymore.
What an enlightening conversation, and that's what was needed here, is to shine a light on what the actual law may be and how we have gone so far away, so awry of something that was enshrined in 1964 when it comes to discrimination. The Commissioner of the EEOC, Andrea Lucas, thank you so much for joining us today here on The Will Cain Show.
Thanks for having me.